Welcome to this deep dive. We're looking today at the 1961 Turkish Constitution, using materials from Turkish law talks.
That's right.
Our aim really is to get a handle on its main characteristics and, its binding
With that
force.
legal weight, yeah.
Exactly. And hey, if anything we discuss sparks a question for you listening, please do leave a comment below the video. We'd love to hear from you.
Definitely.
Right then, let's just dive straight in, starting with page 1 of the source material here.
Okay, so right off the bat, the 1961 Constitution is described as, well, both rigid and casuistic. That's highlighted early in the Turkish law talks notes.
Rigid. Okay, so difficult to change, yeah.
Right.
What exactly made it so hard to amend?
Precisely. The rigidity, it came down to a really demanding amendment process. The notes detail it quite clearly.
Okay.
You needed a proposal from at least 1/3 of all the members of the Grand National Assembly, the TBMM.
1/3 just to propose.
Just to propose, yeah.
Okay.
Then it had to get approval from a 2/3 majority in both the National Assembly and the Senate, voting separately.
Wow, 2/3 in both chambers.
Oh!
That's quite a hurdle. Deliberately high, I imagine.
Oh, absolutely. It seems designed to ensure stability, maybe prevent knee-jerk changes, possibly reflecting caution after the 1960 coup.
That makes sense. And I see here something even stricter. One part completely off limits.
Yes, Article 9. It was very explicit. The provision stating that the form of the state is a republic. Well, it couldn't be amended. You couldn't even propose an amendment to it.
So the republic itself was non-negotiable. Got it. Okay, that covers rigid. What about casuistic? What does that mean in this context?
Right. Casuistic here means it was very detailed, very specific. The notes point out it had a larger number of articles than previous constitutions.
How many are we talking about?
157 main articles and another 22 provisional ones. Many of these went into quite specific regulations.
So not just broad principles, but getting into the nitty-gritty.
Exactly. It was diving into the details across many areas, which, while maybe aiming for thoroughness, could also mean less flexibility compared to a constitution based on broader strokes.
More articles, more specifics. A longer, maybe more complex document then. Okay, so rigid and casuistic. What about its authority, its actual power?
Well, Article 8 tackled that directly, its supremacy and binding force. It stated very clearly that laws could not contradict the Constitution.
Standard constitutional principle, but important to state.
Absolutely. And crucially, it declared the Constitution's provisions were fundamental legal rules binding everyone, all state organs, legislative, executive, judicial, administrative bodies, and individuals too.
So, the supreme law of the land, binding on the government itself, how was that actually enforced, though? How do they make sure laws complied?
That's where the Constitutional Court comes in the Anayasa Mahkemesi. This was a key innovation of the 61 Constitution.
Right, you mentioned its establishment.
Yes, it was created specifically to review whether laws actually lined up with the Constitution. This power, judicial review, is what really gave the Constitution its teeth.
So the court could strike down laws.
Exactly. If a law was found unconstitutional, the court could annul it. A very significant step, making sure the Constitution wasn't just words on paper.
A vital check, definitely.
Yeah.
Okay, the notes then move to the general principles, Articles 1 and 2. What did these lay down?
These define the very essence of the state. Article 1 is short and sweet. The Turkish state is a republic, reaffirming the fundamental form.
Can't get much clearer than that. And Article 2. It elaborates, I assume.
It does. Under the heading Characteristics of the Republic, it says, Turkey is a national, democratic, secular, and social state governed by the rule of law.
Okay.
Based on human rights and the fundamental principles set out in the preamble. That's quite a statement, especially compared to what came before.
It sounds quite comprehensive. The notes contrast this with the 1924 Constitution's Article 2, which adopted Ataturk's 6 principles.
That's right. The 1924 one essentially listed republicanism, populism, nationalism, statism, secularism, and reformism. The Republican People's Party principles.
So what are the key shifts in 61?
Well, it keeps secularism and republicanism explicitly. But notice it uses national state instead of, say, populism, statism, reformism, and importantly, it introduces brand new concepts for the first time constitutionally, which were things like a state based on human rights, democratic state, social state, and state governed by the rule of law. This signals a real move towards a more, rights-focused, democratic, socially aware foundation.
A significant evolution in the state's self-definition, then. Okay, moving on to fundamental rights and freedoms. The note suggests the 61 Constitution was a big step forward here.
Oh, absolutely. Compared to 1924, it set up a much broader and more secure system for rights and freedoms.
In what way?
It strengthened the classical civil and political rights, but crucially, it also systematically regulated social rights for the first time in Turkish constitutional history.
Social rights. Like what?
Things related to work, social security, education, though the notes here don't list specific examples. But acknowledging them constitutionally was a major development. It reflected a wider view of the state's duties.
A big advancement. But rights are rarely absolute, are they? Were there limitations? Article 11 is mentioned.
Yes, Article 11 laid out the rules for restricting rights. It said restrictions could only be imposed by law.
Okay, only by law.
They had to align with the Constitution's letter and spirit, and only for specific listed purposes.
Much as?
Things like protecting the integrity of the state, the republic, national security, public order, public interest, general morality, general health, or for reasons stated elsewhere in the Constitution. A fairly standard list, but important.
So rights were guaranteed, but with recognized exceptions. Was there a safeguard against restrictions going too far?
Yes, a crucial one in Article 11. It stated that any law restricting a right could not infringe upon the essence of that right or freedom.
The core of the right had to remain intact.
Exactly. It aimed to prevent restrictions from effectively canceling out the right itself. And again, the Constitutional Court was the backstop, reviewing laws to ensure restrictions were constitutional.
A careful balancing act, it seems. Individual freedom versus state needs. Okay, let's shift to the government structure, the legislature first. A big change here from before.
A fundamental change, yes. The 1924 Constitution had a unicameral legislature, one chamber. The 1961 Constitution introduced a bicameral system, two chambers.
What were they called?
The National Assembly and the Senate of the Republic. Together, they formed the Grand National Assembly of Turkey, the TBMM.
Two chambers. Why the change, do you think?
Likely to bring more deliberation, perhaps different perspectives into lawmaking, a check and balance within the legislature itself.
Makes sense. Tell me about the National Assembly, the lower house, presumably.
Yes, it had 450 deputies, all directly elected by the people. That's Article 67.
And eligibility.
Article 68. At least 30 years old and literate in Turkish. Interestingly, the Constitution didn't dictate the exact electoral system. That was left to ordinary legislation.
Ah, so the voting method could change.
And it did. The notes mention several systems were used during this period. In 61, the Don method with a threshold.
Oh.
Then in 65, a national remainder system. And then back to Don, but without a threshold, for the elections in 69, 73, and 77.
Different ways of allocating seats proportionally, reflecting ongoing debates about representation, I suppose.
Precisely. Now the Senate, the notes use this phrase, elitist and tutelary logic. What's that about?
Yeah, that stood out. It suggests a different kind of role.
It really did. The Senate wasn't just a mirror of the Assembly. Article 70 details its composition, 3 types of members.
3 types, okay.
First, 150 members elected by the people. Second, 15 members appointed by the president for 6-year terms.
Appointed members. Interesting. And the third?
Lifetime members, called natural members. These were former presidents and members of the National Unity Committee, the group from the 1960 coup.
Lifetime senators. So the elitist and tutelary idea means it was meant to be a sort of guiding, perhaps more experienced or stable chamber.
That seems to be the logic, yes. Bringing in experience, maybe a less directly political perspective via the appointed and lifetime members, acting as a guardian, a tutor almost.
And the eligibility requirements reflected that. Were they different?
They were stricter. Article 72. You had to be at least 40 years old and have completed higher education. Compare that to 30 and literate for the assembly.
Definitely points towards that elitist or experienced profile. Okay, so a bicameral system balancing direct election with this more curated Senate. Let's look at the executive now. What was the setup?
The 61 Constitution, Article 6, set up a dual executive, power shared between the president and the Council of Ministers, both operating within the law, of course.
A classic parliamentary feature, right? Shared executive.
Exactly, not concentrated in one office.
Let's start with the president. How was the president chosen?
Elected by the entire Grand National Assembly, both chambers together, had to be from among their members at least 40 years old with higher education.
And the voting.
Secret ballot needed a 2/3 majority. If no one got that in the first 2 rounds, an absolute majority was enough later. The term was 7 years, Article 95.
A specific process.
Yeah.
And the Council of Ministers.
Yeah.
The cabinet.
Right. Led by the Prime Minister, who was appointed by the president but had to be a member of the TBMM.
Okay.
The PM then chose the other ministers. They could be TBMM members or just eligible to be elected. These choices then needed the president's formal appointment, according to Article 102.
So PM appointed by president, ministers chosen by PM, approved by president. What about their accountability to the legislature? You mentioned a parliamentary system.
Crucially, yes, Article 103 required the Council of Ministers to get a vote of confidence from the National Assembly, not the Senate, the Assembly.
Ah, so the directly elected House held the power to support or bring down the government.
Precisely. That confirms it. In terms of formation and responsibility, the 61 Constitution established a complete parliamentary system for the executive government.
Very clear. Okay, let's turn to the judiciary. Independence was highlighted earlier.
Yes, Article 7 was explicit. Judicial power exercised by independent courts acting on behalf of the Turkish nation. And the Constitution took steps to guarantee that independence.
What were the key measures?
A major one was creating the High Council of Judges, Yüksek Hakimler Kurulu, for the first time.
What did it do?
It handled crucial matters for judges: appointments, promotions, transfers, discipline. The idea was to shield judges from political or executive influence in their careers.
Insulating the judiciary. Any other structural supports?
Well, the high courts themselves, Court of Cassation, Yargıtay, Council of State, Danıştay, were directly regulated in the Constitution, giving them a stronger constitutionally embedded status.
And of course, the Constitutional Court we discussed. Its role must have been central here, too.
Absolutely central. Its power of judicial review, overseeing the constitutionality of laws, was the ultimate backstop ensuring the Constitution's supremacy and the rule of law, a major pillar of the whole system.
Right, so a significantly empowered, more independent judiciary overall. Now, the final section in our notes covers the 1971-1973 amendments. These seem quite significant.
They were. The notes categorized them usefully: changes strengthening the executive, changes affecting rights, and changes to the judiciary.
Let's take the executive ones first. What happened there?
The Council of Ministers got more power. They were authorized to issue decrees with the force of law, bypassing Parliament in some cases.
Free powers, okay. What else?
More flexibility on taxes, duties, fees changing exemptions, rates within legal limits. Also, university autonomy was weakened, and the autonomy of TRT, the state broadcaster, was abolished entirely.
A definite shift towards a stronger executive branch, then. Seems like a reaction, perhaps.
It certainly tilted the balance established in 61, suggests maybe pressures or a feeling that the executive needed more clout.
Okay, what about the amendments concerning fundamental rights?
These were also impactful. A new general restriction clause was added, applying to all fundamental rights. This potentially made it easier to limit rights across the board.
A blanket clause.
Yes, and the specific constitutional and legal reasons for restricting various rights were expanded, plus a very concrete change. The right of civil servants to form trade unions was abolished.
That's a major rollback on a specific right. So generally, a narrowing of rights protections.
It certainly looks that way, yes. A shift from the more expansive approach of the original 61 text.
Okay, finally, the amendments affecting the judiciary during this period.
Several key changes here, too. First, accessing the Constitutional Court got harder for political parties. The rule changed from any party represented in the TBMM to only parties with a formal group, usually requiring more seats.
Limiting access for smaller parties, then.
Effectively, yes. Also, a new provision said the Constitutional Court could only review constitutional amendments on form, procedure, not substance.
Taking away substantive review of amendments. Interesting. What else?
The Military High Administrative Court was set up, taking jurisdiction over military personnel matters away from the Council of State, and state security courts were established,
Okay.
with their members nominated by the Council of Ministers. That raised questions about judicial independence in those specific courts.
Nominated by the executive.
Yeah.
Yeah, I can see how that would raise flags. So these judicial amendments seem to potentially curb judicial power or independence in certain areas.
That appears to be the trend, yes. Reducing scope or increasing executive influence in specific judicial domains.
It's really clear that this 1971-73 period brought major changes, altering the original balance and character of the 1961 Constitution quite significantly.
Absolutely. It marks a distinct phase, a noticeable evolution or perhaps deviation from the initial setup. Understanding these amendments is really key to grasping the full story and legacy of the 61 Constitution.
It certainly highlights how even a rigid constitution can evolve under political pressure.
Yeah.
This has been incredibly insightful, really walking through the structure, the principles, and the later changes, a complex but vital piece of Turkish legal history.
It really is a fascinating document reflecting a specific moment and its subsequent evolution.
Well, thank you for guiding us through that detail. And for everyone listening, that brings us to the end of this deep dive.
Thanks for having me.
Remember, if you found this interesting or have questions, please leave a comment. And don't forget to subscribe to the Turkish Law Talks YouTube channel and like this video to support more content like this. Thanks for tuning in.